Now open, you may be seated.
Good morning, Simon.
Booker versus Regional 5, Administrative Justice and another.
Mr. Kehoe?
Good morning, Your Honors. I'm Ronald Keogh, representing the Region 5 Administrative Justice in this matter of an appeal and a cross-appeal from a judgment entered by Justice Spina on January 14, 2005. The Commonwealth's position is that, number one, the plaintiff, the petitioner rather, Ms. Cooper, is not entitled to 211(3) relief because she did not avail herself of an available remedy in the trial court when she was appointed and objected to her appointment at the legislative rates of pay. She could have sought in the trial court to be excused from the appointments on any of the grounds that she now argues in this court, but did not present to the trial court Justice Tian. The single justice mentioned two possible grounds without really explaining what the legal basis for his January 14th judgment was. He mentioned that, contrary to the interim order which he had entered on August 17th, 2004, it turned out that Ms. Cooper did not have a current bar advocate contract with the Hampden County Bar Advocates Organization, and that because she did not have a contract, she was not required by his interim order to be appointed against her will at the legislated rates.
Mr. Kehoe, excuse me.
Yes, Your Honor.
Was the unavailability of 211(3) relief raised with the single justice?
It was, Your Honor. It was raised as one of the reasons for denying the petition. I might add that the single justice entered his judgments of January 3rd and later on reconsideration of January 14th without ever holding any hearing. The only hearing before the single justice in this matter was on the Commonwealth's motion to vacate the January 14th judgment, which was denied in a one-sentence written order, and followed by both the Commonwealth's appeal, subsequently Ms. Cooper's cross-appeal, and also by the filing by the Commonwealth of a protective 211(3) petition of its own, seeking to present all the issues on the merits in case there were any procedural problem with the appeal being premature or from an interlocutory order.
Counsel, are you suggesting that if Ms. Cooper had raised the arguments that she's raised here, that the trial court would have done anything differently?
We'll never know, Your Honor. What Judge Tian ordered was the denial of her motion to be paid $60 an hour when the legislated rate was $37.50 per hour. In doing so, he recited twice in his order, no judicial authority. But he was saying he had no authority to order payments at $60 an hour. He was never asked by Ms. Cooper to excuse her from the appointments if she couldn't get the $60 that she wants. And so he never addressed that question, of course, because it wasn't presented to him, nor were any grounds presented on which he could have addressed that question. The grounds referred to in the January 14th single justice judgment are two: the lack of a current contract, and secondly, that she claimed now before the single justice that it was a financial hardship for her to take so many cases at the legislated low rate. Well, those arguments were never presented to Judge Tian in the trial court, and therefore he made no order. There was an available remedy, and more importantly, he made no factual findings which the single justice could then review on 211(3). The matter came before the single justice on a petition in which Ms. Cooper still did not advance the lack of a contract, although it's mentioned in a supporting affidavit almost in passing. It wasn't listed in her petition to the single justice as a ground for any form of relief.
Mr. Kehoe, again, forgive me for interrupting you. Is there anything to suggest that Judge Tian knew that she had not executed a current contract?
No, unfortunately, and that's part of the problem for not having made a factual record at the trial court level, Your Honor. The trial court was presented with lists furnished by the Hampden County Bar Advocates, and very well may have assumed from the list on which Ms. Cooper appeared, with a C next to her name, that she had a current contract. The single justice was misled initially into thinking that she had a current contract, and he based his January 3rd judgment denying her petition on the fact that she had a contract for which the Commonwealth was a third-party beneficiary, and therefore she was obligated to accept assignments at the legislated rates. But that was then turned into a motion for reconsideration in which Ms. Cooper, for the first time, squarely presented to a court the fact that she had not signed a bar advocate contract for the year 2004. Judge Tian was never made aware of that.
I take it, therefore, that the claim that Ms. Cooper makes that there is something unfair, I mean, I'm not putting words into her mouth, about a judge calling in people and asking them to take cases simply because at some time they have been a bar advocate, and then putting on them the burden of showing that they can't afford it or the caseload is too heavy, wouldn't arise if the trial judge was assuming that she had already signed a contract as a bar advocate. In other words, viewed one way, you could look at this case, as I did, and say, well, why is a judge in the trial court calling on people to essentially take these cases at a very low rate simply because in the past they have been bar advocates as opposed to reaching out to anybody in the community?
It may well be that if Ms. Cooper had made Judge Tian aware, as she later belatedly made the single justice aware, that she did not have a current contract, very possibly the trial court would have said, well, let's look at my authority here. It flows from the so-called interim order entered by the single justice after this court's decision in the LaValle case, in which there are two paragraphs of the interim order that authorize the trial court justices to appoint lawyers. Paragraph 1 is really not applicable here because it applies to lawyers who are both willing and capable. Ms. Cooper, of course, is capable, but the question she presented was, I'm not willing to serve at that rate. Paragraph 2 of the interim order, post-LaValle, the single justice recited that other lawyers, besides those who strike that. In paragraph 2, he deals with lawyers who had signed bar advocate contracts. Well, Ms. Cooper had signed such contracts up through the year 2003, did not do so for 2004, but until August 17th, the date of the interim order, she was accepting assignments as if she had a contract. And that's why she got listed on the Hampden County Bar Advocate list as still having a contract. There was confusion. It was incumbent upon her to make it plain to the trial justice that, well, I don't have a contract, and paragraph 2 of the single justice's interim order seems to say that I can be excused if I don't have a current contract. What paragraph 2 of the interim order says is lawyers who had signed bar advocate contracts, which includes Ms. Cooper, will be appointed pending an inquiry into the current status of contracts between them and the HCBA, the Bar Advocate Group. So that was an invitation in paragraph 2 of the interim order for any such lawyer, such as Ms. Cooper, to come forward and say to the trial justice, look, paragraph 2 doesn't apply to me because I don't have a contract. She never presented that. Judge Tian never addressed it. The single justice was himself misled until the motion for reconsideration of the January 3rd judgment, in which Ms. Cooper for the first time made a court aware, I don't have a contract. The single justice thought that that was dispositive. So then you look back behind the interim order. It's narrower than this court's decision in the LaValle case. In LaValle, at page 249, footnote 18, this court delegated to the single justice the authority to provide an administrative structure to make sure that attorneys were timely appointed for indigent criminal defendants, and recited in that footnote that those attorneys would be paid at the legislative rates of pay. This court did not authorize any other judge, including the single justice, to make an exception to those legislated rates of pay. So when the single justice thought that because there was no contract, he now had to provide for some new remedy for Ms. Cooper, that's where he went astray. Because neither the interim order nor this court's decision in LaValle nor Rule 6.2 says that an attorney has a remedy of more money than the legislature has provided. Nowhere is there authority in the background of what happened on January 14th, 2005.
So the lesson, or at least one of them for the future, would be to all attorneys in the state, if you sign a contract to handle these cases, don't complain about the compensation level in the future. You're stuck.
Well, that's the way the single justice saw it. That's not the way that we see it, because we think he, in his second paragraph of his interim order, reduced the scope of the authority to appoint lawyers who are not willing to serve at the legislated rates. He narrowed it down to those who seem to have a current contract. But that's not what the LaValle decision said. It said that lawyers can be appointed whether they're willing or not at the legislated rates. The court was there.
You're talking about footnote 18?
Yes, Your Honor.
I confess, and I think my reading is slightly different, which is there's CPCS, and then there's a list of bar advocates, and there were claims made that between those two sources there were insufficient numbers of counsel available to provide representation to indigent defendants in criminal cases. And what the court, I think, said was, notwithstanding the fact that that is the way the system works essentially all over, unless you retain private counsel and fund counsel yourself, if you're a not if you're a criminal defendant, that the Chief Justice for Administration Management and the Regional Administrative Justice could pull together lists of attorneys in addition to those who might have had contracts with bar advocates and might be CPCS attorneys. I think that's what the import of footnote 18 is. You're quite correct. It says nothing about what the compensation would be, but I assume that implied some kind of willingness of attorneys to be listed on such a list, and if they were asked by a judge, presumably they could invoke 6.2 and say, I can't afford to do it, or I can take 4 cases but no more, whatever it is. I mean, I think that's my memory of what the import of footnote 18 is. Here, if she didn't have a contract, then we're almost into the judge is asking her to take on cases, as you say. She says, I can, but only if you only give me a few, or, I can be paid at a different rate. He says, I can't pay you at a different rate. And she says, well, then I can't take the cases. But we don't have that.
It's that last statement that she never made.
Correct.
She said she was unwilling to take the cases at the legislated rate, but she was willing and able to serve, and in fact did take these cases,
Correct.
Dozens of these cases, and worked them while preserving her right to claim more.
Correct.
But she never presented to the trial justice any reason why, other than her desire for more money, she should be excused. She didn't ask to be excused.
Correct.
She just objected, registered her objection, and said, I want $60 an hour. If she had asked to be excused on any ground, whether it's financial hardship or lack of a contract or other good cause, as Rule 6.2 says, she might very well have been let out of these cases and we wouldn't be here today. So for those reasons, I hope that this Court will not see fit to reach the merits of her claims about the judicial inherent authority to appoint counsel or about the authority to pay more than legislated rates on the various arguments that have been made here. What it comes down to is that LaValle stuck to the O'Coins doctrine, that only in extraordinary circumstances, to protect its own functioning, can a court order higher rates than the legislature has authorized. There's nothing in LaValle. In LaValle, this court refused a major attempt by the bar advocate community and CPCS to get this court to exercise the O'Coins power. And a single justice ordered higher rate without even addressing O'Coins, not to mention making any findings under O'Coins. But as I say, it seems to me that it seems to us that the court can dispose of this case without ever reaching these weightier issues, because the matter was never properly presented and a factual record was never developed that would enable this court to review the matter properly.
Thank you, Mr. Keogh.
Thank you.
Mr. Thompson?
Thank you, Chief Justice Marshall. May it please the Court. I represent Rosemary Cooper, and I think I'll start in the same point or with the same issue that Mr. Keogh did, and that has to do with...
Why shouldn't we just avoid the whole thing based on what he just argued, that procedurally she did not protect her rights properly? Because the other issues are fairly, well, they are very, 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 very substantive, and they may most likely not reoccur. I mean, I've been here 15 years, the first time this kind of thing has come up. Well, the procedural record is just not good enough for handling this. What do you say to that?
Well, I disagree, Justice Greeney. I do agree that these are serious issues, but I think that they're likely to recur. They came close to recurring this summer. And I think that as long as the legislature follows the pattern that it has for years of underfunding and not following the CPCS recommendations on what the compensation levels should be, that these kinds of crises will recur. But I want to go to the
Mr.
record.
Thompson, it would be very helpful to me if you could explain to me, from at least where I'm sitting at the moment, and explain to me why I'm wrong. There's CPCS, there are people who have current contracts as bar advocates,
Yes.
who perform incredibly important services without which the system wouldn't function. And then there are people who take assignments. In other words, they are not retained by defendants. They are assigned, but who do not have current contracts with bar advocates.
Yes.
As I understand it, Ms. Cooper falls into the latter category, correct?
That is correct, Justice Marshall.
Why could she not have raised before the trial judge essentially what 6.2 provides for her, which is even if you are asked by a judge, you can come in and say, I can't afford it, or I can't afford all of these cases, or I don't have the capacity to, whatever the arguments are. I mean, 6.2, lays out a whole
Yes.
series. Why couldn't she have done that?
Well, she could have asked to be relieved under Rule 6.2.
Right.
She specifically did not. Her motion, her objection to the order is in the appendix at page 33.
Right.
It does, she raises two objections to the order that she be involuntarily appointed. One is that this was an abuse of Rule 6.2. The other is that the compensation was inadequate. And she specifically said that she was not objecting on financial hardship grounds at that point.
Tell me whether Judge Tien knew that she didn't have a current bar advocate's contract.
I don't think that the record shows whether Judge Tien knew that or not, but I think the record does show why it wasn't an issue, a prominent issue in the district court.
Why? Because
Well, for one thing,
it makes a big difference.
The LaValle orders that we're talking about were non-published orders, and there's no indication in the record that she was aware of them. The orders that she was given...
That doesn't make any difference. She says, and I have enormous sympathy for this position, I get a call saying, show up in court, and believe me, it's happened to many of us, say, we've got a case here that needs counsel. It's typically indigent criminal defendants, but it can be indigent parties in other cases. And you say to counsel, I'd like you to take this case. And there's usually a colloquy with the clerk, and you say, I'd love to do it, I'd love to help out the court, but I just can't do it at the moment. Usually that's for zero compensation. And essentially, given that I think it would be fairly well established that compensation of $35 an hour is not the going rate for sophisticated criminal defense counsel such as Ms. Cooper, it's a pro bono piece of it anyway. And if she had said, look, I've got no contractual obligation, whether or not a bar advocate with a current contract had a contractual obligation is a different issue. But if she'd said, I can't continue and therefore shouldn't be assigned these cases, wouldn't that have made it more clear as to what the issue here is?
I don't think so. And that is because if you look at the orders that were issued and at the correspondence that was directed to bar advocates, there was the one clear message was, it doesn't matter whether you want to do this or not. And as a matter of fact,
that's to bar advocates. That's precisely that is people who have current contracts. But a bar advocate is somebody who's got a current contract as a bar advocate.
Actually, Justice Tien's letter to Attorney Bonavita on August 12, 2004 says, my use of the August 2, 2004 list of Hampden County bar advocates is not premised on whether the attorney is presently in the program, but that qualifications have been met with CPCS. In other words, it didn't make any difference whether she had a contract or not.
Well, again, that misses a point. In other words, who's on the list? The list is, we have established minimum qualifications of which she clearly meets, and so a judge is not going to put onto the list people who are not currently bar advocates. There was a big dispute about that. And CPCS argued persuasively, I think, that we should ensure that whoever is on the list is qualified. Obviously, if you are or have been a bar advocate, you are qualified. But that doesn't say what in other words, that's just getting you onto the list. What that doesn't address is what a bar advocate who doesn't have a current contract should tell a trial judge when the trial judge assigns cases.
Well, Justice Marshall, the trial judge has said we're using the bar advocate list to select qualified people, but it doesn't matter whether you're in the program now or not. You're being conscripted.
But this record doesn't establish that, and that makes an enormous difference.
This is Justice Tien's letter to the president of the Hampden County Bar Advocates on pages 15 and 16 of the appendix. And and on page 17 is the order that was issued to Ms. Cooper. And the last paragraph says, your appointment on this date is not made in your capacity as a bar advocate. That list is being used because of CPCS approval of your qualifications.
Yes, and that's fine. And so you are appointed because you are qualified, and then you come before the judge and you say, Judge, I don't have a contract. That's Mr. Kehoe's point. Judge, I don't have a contract. I can't take these cases. And if I had that record, and if the trial judge had said, the judge in the trial court had said, that's too bad, because she then stands as any other member of this bar.
She was being treated, I think that mischaracterizes the nature of this program.
Okay, help me.
That is, the bar advocate, this is not a drafting of bar advocates. There were 44 attorneys who were conscripted in this way. 20 of them did not have contracts. The communications that the lawyers got before they were required to report for a duty day, there were two communications. One went to Mr. Bonavita, the president. It said, it doesn't matter whether you have a contract, whether you're in the program. The second one went from Judge Teehan to the individual lawyers. It says, you are not being drafted because you're in the program. You're being drafted because you meet the program's qualifications.
But then,
So the
but then surely the latter category of attorneys fall under Rule 6.2, correct?
all of the lawyers fall under Rule
All under the
6.2.
Well, the bar advocates may or may not, because if you signed a contract, you may or may not fall under 6.2. I'm not even going to get into that. I'm talking about the conscripted, the 20 conscripted lawyers. And
Rule, excuse me, Justice.
No, and then you go and you say, can't do it, cannot do it, don't have a contract, can't. I know I'm on this list because I'm qualified, but I cannot do it, or I can take one.
They had not been distinguishing between people who had contracts and who did not have contracts even before this. Ms. Cooper had been a volunteer. That is, she had been taking appointments up until May of that year, when she felt so overburdened that till April, she quit taking appointments. And she was called and requested and asked to participate. And she said, I will do this for $60 an hour.
Well, Mr. Thompson, I think all this makes clear the folly of our trying to determine this when this wasn't all the subject of advocacy below and then findings by the judge. And I'd like to ask you, when you were asked before,
Yes.
why we should consider this on the merits when the grounds were not raised below, and so the judge didn't have an opportunity to make findings on them. Is your only response to that because this might recur, or do you have another reason why we should decide this nevertheless?
Yes, I would say because Ms. Cooper did properly present her case to the trial court. She made her claim. She presented exactly the claims that she has here. That is, this was an abuse of Rule 6.2, and she should receive fair compensation for her work. Those were her claims. That was fully developed. She, in her petition to the single justice, she stated that she did not have a contract. It did not become clear that the single justice considered the contract to be pivotal, and that the legally decisive issue was whether or not she had a contract, at least in terms of whether she could be conscripted and whether she had to settle for the $37.50 an hour. As soon as that became clear, she presented it. Now, there was an opportunity at that time to litigate that issue, but the respondents did not litigate. They didn't file proper responsive pleadings to Justice Spina's ruling on the motion to reconsider. So Ms. Cooper's case is properly before this court. There wasn't a remedy that she could pursue that she didn't pursue. She went to Judge Teehan. She asked for an evidentiary hearing, and that was denied. Judge Teehan's order is on page 48 of the appendix.
She asked for an evidentiary hearing on what point?
She asked for an evidentiary hearing on the question of whether on her objections.
That is on compensation.
Yes. His ruling was objection to order of assignment denied. Motion to be paid $60 per hour, no judicial authority. She specifically asked under Rule 310.5 and fiscal year budget line item 03300300. This was very well presented in the trial court.
Mr. Thompson, even if she invoked Rule 6.2, is there not a contradiction between an attorney saying, I will accept if I'm paid $60, and the judge in the trial court says, I can't pay, I don't have the authority to pay you $60, and she then says, well, then I can't take the cases. The problem is she said, well, I'll take the cases anyway.
This case grows out of LaValle, Justice Marshall, and as the court noted in LaValle, the core problem here was inadequate compensation for lawyers. Ms. Cooper was trying to volunteer. She said she was willing to do this work. It's not the most, even at $50 an hour, you're making less than a plumber.
Believe me, $60 an hour I'm prepared to accept isn't what she would earn as a very experienced criminal defense attorney at market rate. So
As her affidavit lays out, she has made considerable personal sacrifices
Of course.
to continue doing this work. It was reasonable for her to say, I will continue to do this work. That's what the court needed. It was also reasonable for her
But if
to
the
say,
court
I
says-
need better
But if
compensation.
the court says, I don't have authority to order you better compensation, the response of an attorney is, then I can't do this work for you. I can't volunteer.
Well-
And that's a perfectly reasonable, and then if the judge
Yes.
says, I don't accept that, in other words, the hearing is not, would $60 be enough, but to say, I don't accept that and I'm nevertheless assigning you counsel, that would present the issue, I think, that she wants this court to resolve.
There's another alternative, Justice Marshall. The the line item that I mentioned authorized higher payment and authorized the court to pay out of the trial court budget a higher rate to these attorneys, and some courts did. She felt that she should be able to press that issue, and the only way to do that is to object to the appointment, or a reasonable way to do that is to object to the appointment, accept the appointment, and press her legal point by appealing and by filing filing a 211 section, this action here, which is the method that the respondents are saying she should have followed. That is, you make your objection to the trial judge, and then Justice Spina was available on short notice to review these. That, again, was an order issued in La Valley and not in public circulation. But she followed that procedure. There isn't another procedure that she could have followed. And the fact that she wasn't given an opportunity to develop the facts more fully doesn't mean that we don't have a well-presented case that's been fully briefed and presents important issues that the court should decide.
Thank you, Mr. Thompson.